A grieving Muslim woman. In Sharia terms, the death of one's husband or divorce ends the relationship of the grieving woman as his wife. In Sharia, as per common sense and logic, nikah is valid only with a sane living being. A severance upon the death or divorce, therefore, logically and legally, makes it permissible for a widow/divorcee to marry another person after her waiting period, iddah, is over. A waiting period, iddah, of a widow/divorcee does not represent grieving for the deceased/divorced as her husband but ex-husband, and to ascertain her pregnancy status for genealogical and inheritance purposes, so that after its completion she can exercise her choices with certainty and clear mind, fulfilling Sharia injunctions. Extended mourning, fantasizing about the deceased spouse in an amorous way, by man or woman, donning a black dress to exhibit grief, visiting the grave, as that of her husband, by a believing woman, etc., is a reprehensible behavior of a believing woman. Praying for the forgiveness of one's deceased spouse and or the enhancement of their ranks, reduction/elimination of grief, of those related to them is permissible like for any other believing person. Islamic Corpus Juris. Atiyah reported that the Messenger of Allah, peace and blessings of Allah be upon him, said, "No woman should mourn for a dead person for more than 3 days, except for a husband, in which case the period of mourning is 4 months and 10 days. Reported by Muslim, 2739. Habibah bint Abi Sufyan reported, "I heard the Prophet, peace and blessings of Allah be upon him, say, it is not permissible for a believing woman to mourn for any dead person for more than 3 days, except for a husband, in which case the period of mourning is 4 months and 10 days. Reported by Al-Bukhari, 4926. In the hereafter, a woman will not automatically become the wife/companion of her ex-husband against her will and choice. The word wife for the afterlife is used in a figurative sense only as the temporal Sharia will not be applicable there. Another thorny issue is divorce. Divorce is valid only when it is deliberate and seriously intended, not what has generally been believed, to be post-haste or pestilent. This is why divorce uttered thrice in one go is considered once. Dislike of divorce by Allah, SWT, is also an indication for it to be well thought out, deliberate, and a last resort decision. A prominent hadith asserts that the actions are predicated by intentions. Another even more prominent one asserts that Allah has forgiven the sins committed by my ummah by mistake, forgetfulness, or under duress. A solitary hadith, creating an exception by contradicting the collective wisdom delivered through Quran, is that the divorce becomes effective even if pronounced in jest or by mistake. It does not seem to hold water due to the lack of corresponding or corroborating with either the Quranic text or other ahadith on the topic. It may, however, be possible that this was issued, with limited application to stem the abuse of divorce and resulting socioeconomic and familial issues, at a particular time or in specific circumstances. Allah knows the best. Divorce also does not take effect in a state of extreme anger or under the influence of intoxicants. Due to an insanity-like situation. The Prophet said, "There is no divorce and no freeing of slaves when it is done by force or in a state of intense anger." Narrated by Ibn Majah, 2046, classed as Sahih by Al-Albani and Al-Urwa, 2047. Greater than what is a halala/talil marriage in Islam? Here is the hadith in question with relevant commentary. The scholars differed as to whether a divorce given in jest counts as a divorce. The majority are of the view that it does count as such, and they quoted as evidence the report narrated by Abu Hurairah, may Allah be pleased with him, who said, "The Messenger of Allah, peace and blessings of Allah be upon him, said, there are 3 matters in which seriousness is serious and joking is serious: marriage, divorce, and taking back one's wife." Narrated by Abu Dawud, 2194, Al-Tirmidhi, 1184, Ibn Majah, 2039. The scholars differed as to whether this report is Sahih, sound, or Da'if, weak. Al-Albani classed it as Hasan in Urwa al-Ghalil, 1826. Ibn al-Qayyim tried to put his words in Allah's mouth as follows. These sunnahs imply that one who is accountable jokes about divorce, marriage, or words, although taking back his wife, then what he joked about becomes binding on him. This indicates that the words of a joker carry weight even though the words of a sleeper, one who forgets, one who has lost his mind, and one who is forced do not count. The difference between them is that the joker intends to say the words, although becoming binding on him, he does not want the ruling on his words to apply. It is not up to him. Rather, uttering these words is up to him, but as to and fro, the ruling on those words, that is up to the lawgiver, whether the person intended it or not. What matters here is the word that he chose to use willingly when he is of sound mind and accountable. If he intended to utter these words, then the lawgiver will apply the ruling to him whether he was serious or joking. This is unlike one who is sleeping or the one who has lost his mind or one who is insane, etc. They do not have any real intention and they are not accountable, so the words that they say are idle talk, like the talk of a child who does not understand what he is saying and does not mean it. The heart of the matter is the differentiation between one who says something deliberately, knowing what he says but not intending to be subject to the ruling on what he says, and one who does not mean it and also does not know what it implies. I will let the readers make up their own minds by paying attention to the italicized phrases concerning the application/significance of intention. Ibn al-Qayyim, in my understanding, lost track in the zeal of justifying his opinion on a doubtful hadith. I seek Allah's forgiveness in tendering my meager opinion. Right of divorce, khula and separation time between husband and wife. Allah Ta'ala endowed only the husband with the right to grant a divorce. A woman, however, is given a right to seek khula but cannot assume or assert it without the husband having accepted and granted it. Unlike her husband, she has to have a valid reason to seek khula. The husband can replace a wife if he is emotionally/psychologically done with a wife. Q. 420. If you want to divorce a woman so that you can marry another, do not take back the dowry which you had paid, even if what you paid was a large amount of gold. The separation between husband and wife. It is a very pertinent question for lots of people who are separated for the sake of overseas employment or a deliberate separation for the sake of separation. Sometimes such spouses may decide to reunite, but lack the understanding of the implications of a long separation. As Shaykh Ibn Jabreen, some of the Sahaba set a limit for a husband's absence at 4 months, and others set it at half a year, but it applies when a wife demands her husband to come back. If he has been away for half a year and she asks him to come back, then he must come back. If he cannot or refuses, then she has the right to seek khula and may refer the matter to the qadi, judge, seeking khula, and have the marriage annulled. But if she allows her husband to stay away even for a long time, any number of years, then there is nothing wrong with it because she has willingly waived her right to intimacy. Provided, her provision, clothing, and other needs are assured. And Allah is the source of strength. Fatawa Islamiwa, 3-212, a woman can also waive her right to provision. Researched and composed by Shakir Mumtaz. Author, thinker, analyst.